Hello, everybody, and welcome to our continuing coverage of the Commonwealth versus Karen Reed. We are here today to discuss some pending motions. We're going to start with the defense's response to the state's motion to exclude Dr. Green, the defense expert who testified about Jennifer McCabe's cell phone, and to the fact that there was a house long to die in the cold search at sometime after 2 o'clock in the morning. The interesting thing is that since the trial, the Celebrate has updated its software. And I have to tell you the truth, you guys, and maybe this is a unpopular opinion, but I don't know where I fall, whether I really think this search occurred or not. I did some research into the mechanics and the data and the technical side of it and thought that I figured it out and thought, no, that doesn't make sense. The search did happen, but now I'm not so sure. So I think at the end of the day, the judge is definitely going to allow this expert to testify. I can't imagine under the law how she could exclude him, but I think that the jurors are probably just going to discount it. It's going to be one of those things that they say, all right, we're ignoring it. It didn't happen. It did happen. Which obviously only hurts the defense in that situation since it's not part of the state's case at all. So what we have is the defense's response, which primarily focuses on, well, I won't say primarily, which partially focuses on just it being unsupported by an affidavit, and for that reason, insufficient on its face alone, and that the court should just dismiss it on its face and deny even giving them an evidentiary hearing. But the overall primary gist of it, which is legally sound, is that all of the, in my opinion anyway, is that all of the defense, this Commonwealth's arguments go to the weight, go to the opinion, not the experts' credentials, training, experience, and not the methodology. That they're really challenging him almost not using the updated version of Celebrate, where the defense is focusing on this expert has used multiple tools. The Celebrate tool was not the only tool that this deleted artifact, whatever, demonstrating that the search occurred around 2 o'clock in the morning, was deleted or did occur, any of those things, that it was on other applications as well, and it showed up as part of his overall analysis. But at the end of the day, believe everything the state wants to say, and you're still left with that is a question for the jury. And I believe that the Commonwealth is right in this regard. So I will, much to my chagrin, because Bob is currently finishing up his episode of recording his episode for Garcia, I will read the entire document, although I do think that there are parts that we could skim, but I know you guys like it this way, and not about to do it different when Bob leaves me for a hot minute. So, and he will be joining us soon, by the way. So let me share that with you guys. And now I'm talking about what I'm doing the same way that I complain when Bob does. Okay. So this was filed January 26th, and it is the defendant's opposition to the Commonwealth's motion to exclude certain testimony of defense witness Richard Green. So you've got the preamble. Now comes the defendant. Karen Reed respectfully requests this honorable court deny the Commonwealth's motion to exclude expert testimony of Richard Green as to. Now, this is the defense reiterating the Commonwealth's position. One, his expert opinion that a Google search for how long T die in CKD or house long to die in cold was made on Jennifer McCabe's phone prior to 6:23 a.m. on January 29th, 2022. And two, his expert opinion that Jennifer McCabe's phone incurred user deletions of any data related to Google searches and deny the Commonwealth's, I think it should say motion, including, oh, and deny the Commonwealth's included request for an evidentiary hearing under the standard set forth in Daubert v. Merrill Dow Farm. So, and Daubert is the U.S. Supreme Court case that deals with the gatekeeping function of the court before expert testimony can be presented to the trier of fact, be it a jury or a judge. Now, I've highlighted this because, again, I think it sort of summarizes the opinion well. The defense goes on to say the Commonwealth has not made any showing that the qualifications or methodology of Mr. Green do not satisfy Daubert or Lanyon, and that is a Massachusetts specific case that incorporates and adopts uh, the U.S. Supreme Court of Daubert. Instead, the Commonwealth's entire motion merely addresses the conclusion and opinions of Mr. Green, matters that the court resoundingly state or that the courts resoundingly state are the subject for cross-examination and the jury, not the narrow function of the Daubert, I'm saying Lanyon, I'm not sure, I'm just gonna call it Daubert, judicial gatekeeper. And again, that's what I was describing. That's when the judge is acting as a gatekeeper. All right, what can get in, what can't? This is new science. I've never heard of this science. Like when DNA first came out, and all science when it's new. Once it's established, this is usually not an issue. And you recently saw this in this very same case with um, and now I'll forget the doctor's name, but the doctor testifying about dog bites for Karen Reed, who the Commonwealth also sought to exclude under Daubert, but the judge did not exclude. The defense goes on to state, moreover, as this opposition clearly demonstrates, Mr. Green is, wait, I have to, sorry guys, I've got to look at the here to see if you guys can see. Hold on, try blowing it up. Okay. I'm reading from the PDF version, so I'm not seeing the chat while I'm doing this. Okay. Mr. Mr. Green is eminently qualified, and his methodology pertaining to the subject matter of the instant motion is reliable. So I'm going to restate that. The defense goes on to say, moreover, as this opposition clearly demonstrates, Mr. Green is eminently qualified and his methodology pertaining to the subject matter of the instant motion is reliable. As a result, in addition to denial of the motion, no evidentiary hearing is justified. The motion of the Commonwealth to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach of the Commonwealth to deny Ms. Reed the ability to present her defense through her well-credentialed, methodologically reliable expert witnesses so she can have a fair trial against the baseless charges lodged against her. So let's see if we can see who authored this. does it say? So it looks like probably Alisi. And you see a little bit of a different writing style um, with the newest addition to the defense team, Alisi. The expert witness of the defense here, Richard Green, testified as an expert witness in digital forensics in the first trial regarding his opinion that the Google search for "house long to die in cold" existed in the data form of the iPhone 11 of Jennifer McCabe with a timestamp of at or before 2:27:40 a.m. and in a deleted state in parentheticals to 27:40 a.m. is the search artifact. That's how they're going to refer to it moving forward, without any objection from the Commonwealth as to his qualifications or methodology. And we know that that's a losing argument. That what Lally didn't do, apparently, she's not preventing the Commonwealth from doing this round. Um, Anyway, the defense goes on to say, and for good reason, Mr. Green has been accepted in several United States courts as an expert in digital forensics. The methodology that Mr. Green employed in the first trial was the same methodology the proffered experts for the Commonwealth employed. That is, Mr. Green and the two proffered experts of the Commonwealth received the same raw image file from Jennifer McCabe's iPhone 11, verified the hash signature / value of the image file, took the image file and saved it to their computers, servers, hard drives, etc., and then processed and evaluated the image file with the appropriate tools such as Celebrite, Analyzer, and Magnetic Forensic Axiom. While the Commonwealth witness Ian Whiffen used only the Celebrite Physical Analyzer and ArtX tools, Commonwealth witness Jessica Hyde historically used 3 more tools than Ian Whiffen, and Richard Green used at least as many tools as Jennifer Hyde, with Green and Hyde using 4 of the same tools. Notably, although Jennifer Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Celebrite now are disconcertingly absent from her December 2024 report submitted with the Commonwealth's motion, despite her admonitions of her previous report that it is best to use multiple tools. So what they're saying here, and they say it again, so this isn't the first time you'll hear it, but it's just that Jennifer Hyde said, as part of her testimony, as part of her understanding of appropriate, proper forensics, that it is better to use multiple tools. That is the best practices. But here in her new report, she abandons that and she relies only on the Celebrite tool, which they are, going to call, quote, updated, but that the most recent update made it such that the deletion, the search, no artifact of it whatsoever appears anymore on a Celebrite report based on their updates. Now, let's assume for the purposes of this discussion that what Whiffen testified to was right, that artifact should have never really shown up. It's misleading. It makes it appear as though something was deleted by a human and it wasn't. So what they're saying, their official response, and um, I guess I could bring it up for you at the end, so I'm not bouncing all around, but I'll read it real quick. We update our code regularly based on research and updated understandings on how mobile phone data is stored. This case, the Reed case, underscores the importance of validation. Ian is a world renowned for his decoding expertise, and we fully support and stand behind his scientific findings. His research and methodology for the testing in this specific case was also verified by third-party certified digital forensic examiners. So they're saying that this case brought to their attention an error in their coding. So they fixed it. And the state's saying, oh man, this Ian, who's like was so gung ho for supporting the state and wants to keep all Celebrite's police friends close, is now altering their code just so it will be helpful to the Commonwealth in the Karen Reed case. I don't know. That's like for you guys to decide whether you take it that far. Me personally, I'm I'm not necessarily accepting or rejecting, I guess. I don't know enough. I'm not I don't know enough about the technology and the science behind all of this. I've got to understand it better. But, you know, both sides are pushing their agendas hard. So, all right. So in any event, turning back to what the motion says is they were pointing out how Jennifer Hyde previously used for the same tools as Richard Green, and go on to say, notably, although Jessica Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Celebrate are now disconcertingly absent from her December 2024 report submitted with the Commonwealth's motion, despite her optimisms about in her previous reports that it is best to use multiple tools. Importantly, it is undisputed by all expert witnesses at the first trial that the 2740 AM search artifact was indeed present on the iPhone of Jennifer McCabe after analysis using Celebrate physical an analyzer forensic technology available and on the market at that time. It is thus completely inexplicable how the Commonwealth can now challenge the methodology of Richard Green, whose methodology is the same as and then more comprehensive than that of the digital forensics witnesses of the Commonwealth. It is the opinions and conclusions, not the methodology of the witnesses that differ. But that difference is not a Daubert issue. So again, that's where they're saying that that's a question of fact for the jury. Which expert do you believe? Who's, but it's not a question of how he came about his determination. It's just whether he's making the right determination. What has changed since the first trial? The answer is disturbingly Orwellian and brings the prosecution closer, if not squarely within, the danger zone of legal tyranny. After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement centric digital forensic consultant, appears to have gone back to his company, Celebrite, to have its researchers perform further, quote, updates to its physical analyzer programs such that the artifact containing the 2:27:40 AM timestamp has now suddenly disappeared from all Celebrate programs. And he cites to the affidavit of Green, which is an exhibit to this motion. The 2027:40 AM search artifact has now nefariously become, without explanation, the Orwellian unperson. So I'm sure everybody knows, but when they say Orwellian, they're talking about the book 1984 and like the all watching, all knowing government um, doing whatever it wants, whenever it wants. So this goes to what I was just explaining to you before. I mean, he said it right there. That is the defense's position. This entire update is bullshit. Um, and again, I'm just not fully educated enough to have an opinion on this at this point. Although I do find it highly suspicious, and I do note that it is important for Celebrate to keep its police community and prosecution community happy. That's where they get their business from. But again, I am not fully accepting this either. So that's that. After Celebrate completely rid itself of the 2:27:40 a.m. search artifact that is incredibly inconvenient to the theory of the case of the Commonwealth now comes before the court saying the unilateral and unexplained Celebrate updates to, quote, remove the 2:27:40 a.m. search artifact should control whether a jury is able to evaluate whose digital forensic theory about the artifact is most accurate. And in doing so, glaringly, the Commonwealth does not address the other forensic tools, such as magnet forensic axiom that Ms. Hyde used in 2023, that Mr. Green used in the first trial, and continues to use up to this day, and that still contains and shows the 2:27:40 a.m. search artifact, nor the several other digital forensic tools that Mr. Green used. Now, I will note that if other forensic tools are not in agreement with Celebrate, that artifact is some sort of misnomer, why aren't they all adjusting their code to make sure that they don't inadvertently pick up something that shouldn't be there? But again, I'm devil's advocating both sides, and stand behind my first opinion that I'm just not fully informed to decide which of the two I believe happened. But additionally, the motion of the Commonwealth is legally insufficient on its face. The motion is not supported by one affidavit. The motion does not even begin to meet its foregoing obligation to state how Mr. Green is now, suddenly after the trial, supposedly not qualified. Nor does the motion even begin to identify what the Commonwealth believes is the proper methodology to address the 2:27:40 a.m. search artifact, or why the methodology employed by Mr. Green to analyze it is not reliable. Perhaps his failure is due to the fact that Mr. Green is eminently qualified, including more qualified in data forensics than Mr. Whiffen, and that the methodology Mr. Green employed includes the same and entire methodology of the proffered witnesses for the Commonwealth, plus his addition of additionally accepted digital forensic tools. Now, the state closes this introduction by saying, to prevent the continued abuses of Miss Reed by the Commonwealth, including the bleeding of her financial resources and the public's, and distractions from her and her defense team's preparation for trial, the invasion of the province of the jury, and other broader jurisprudential maladies, this court must deny the Commonwealth's motion and its included request for an evidentiary hearing. So that is basically what they're going to say in the rest of this 24-page motion. And I'm not stopping or suggesting we don't read. I was just going to take a minute to see
Are
where
you
you
suggesting that you stop and not read? It seems
No,
like
I already told people that I was not going to do that as much as I wanted to kind of summarize and then jump to certain spots. I wasn't doing that when left alone. But I was coming to see if people had questions and where things stood, and it was perfect timing because here you are.
hi.
Hi, babe.
I finished Garcia, episode 64, so I'm excited. Hey,
Wait,
beautiful
didn't you
humans.
didn't you need me?
No, you're coming in on the next one.
All
Like
right.
your response is the next episode. So I'm gonna
All
have
right.
you on to fire away. Fire away. Hey, beautiful humans. You guys, I missed you since yesterday. So what are you into right now?
So we're in the defense's response to the Commonwealth's motion to exclude green. Um, and I've kind of gave everybody a little bit of I kind of told everybody where this was going, and now we're getting into it. But the
I've got
biggest
it up if you want, like, you wanna switch, like, back and forth on reading? So it's
no,
not
yeah, you read, but I got highlights. So
oh, well, I take full advantage of the 2 giant Thunderbolt displays that we have in your area that you use, so I've got them up. I've got it up. So, I mean, are you
Do you wanna
suggesting you
do you
only
wanna
want me to
switch real quick?
do you want me to come up there? You wanna come to your normal hidey hole?
It's up to you. You mentioned that you wanted to, but I can send you my, highlighted version so you use that. I mean, I
So,
can send it
are
to you.
you saying you only want me to read the highlighted portions?
No,
So,
just say
what's the point of the highlighting?
because those are important things, more important than other things.
What am I reading all of it?
You're reading all of it, yeah.
You just wanna highlight the fact that that is an important part of the motion. That's what
Yes.
you're okay.
Yes.
Babe, it's up to you. This is your spot. I know you prefer it down here. Do you probably like the lighting better down here?
I like
Um,
everything better down there, but I'm now
alright,
I've been up
let's
here.
switch it. It'll
Alright.
be quick. Well, you're gonna have to just use my computer and I'll use yours, that's all. It's no big
Oh, but
deal.
I'm not is mine connected to your Thunderbolt?
What?
I don't know, let's stay where we're at. I don't like this idea. Or
Did you plug the mic into your
or we can just
computer?
turn off our cameras and switch places.
Wait, I understand, but you still have to use my computer and I'm using yours.
No, you bring yours back up, I'll bring mine back down.
Well, I'm on the I guess we could switch to Wi-Fi. That'll be
Alright, let's just
that
stay.
sounds like a
People are
giant
we're
pain
gonna
in
be
the ass,
getting,
dude.
like, a
Alright,
bunch of
so
complaints on this shit right now.
oh, well, sorry, folks. I mean, I feel real bad. So,
I'm
did
gonna
you
email you the highlighted version so you can
okay, I'll pull it up. Did you plug in the mic? The Shure?
yes.
Okay, alright,
Yes.
cool. And you made sure to check the settings to make sure that it's using that mic and not
Yes.
your computer?
Yes, thank you, sir.
Just
Wow.
checking, just checking.
Wow. Mansplaining. Bob mansplaining.
Wow, is that what that
Busted.
was?
That was mansplaining.
I've decided that you might be worse than tech than I am.
Yeah, that'll be the
I
day.
think the
That'll
whole
be the day.
tech the tech wizardry
You're
aspect of it relates to both of us very, very
no,
much.
I disagree, sir.
Oh, wow. She is firing. Alright, let's get to this shit. You're probably right at this point, they're bitterly complaining, like, "I wanna hear the read motion." So, I know what they're trying to do, right? They're trying to tell the Commonwealth they could go blow it out their ass, then they don't even wanna have a Daubert hearing, and this is why? Is that what the
Yeah,
solution is?
but you know what? And, I'm gonna read it because I'm sure all the people loved it anyway. Um, I'm just gonna read to you um, this
Oh, I'm
one
I'm so
part.
happy to see the name Ian Whiffen. Whiffen.
I should
Whiffins.
have highlighted, but I was looking at more legal stuff at the time.
I don't even know what page are you on?
The 3rd.
Oh, did you
So,
email it to me?
I did, but you have to listen to this part because you're gonna love it.
I am listening.
Okay. What has changed since the first trial? The answer is disturbingly Orwellian and brings the prosecution closer to, if not squarely within, the danger zone of legal tyranny. After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement centric digital forensic consultant, appears to have gone back to his company, Celebrate, to have its quote researchers perform further quote updates to its physical analyzer programs such that the artifact containing the 2:27:40 a.m. timestamp has now suddenly disappeared from all Celebrate programs.
What?
Uh, the and then it goes to
Wait a
the
second.
affidavit.
So House Long to Die in the Cold at 2:27 AM is no longer in existence anywhere
Not on
on the in the
Celebrate. They updated Celebrate after. Um,
wow, that's some slippery shit. Alright, so what you sent me is this five-page Karen Reed article. It's not the document.
oh, sorry.
It's okay.
All right, we'll continue to read the next sentence while I send it to you.
Alright, I gotta switch back. Okay,
And then ends with the search artifact has now nefariously become, without explanation, the Orwellian quote unperson.
ooh, I love when they use the word nefarious. Okay, so wait, I gotta get on the right page here. Wait, I also have to switch
You're
to
looking at it, just look at on your screen. I have
honey,
it.
that is way too small for me to read with my email
Oh, well,
address, you know
then
this.
just wait, I'm sending it to you.
Okay.
Jesus.
I mean, what difference does it make? Like, there you keep yours up,
I
I'm just
know.
gonna read from mine and you scroll along, you know what I mean?
Oh, I
They're
thought
still
you were gonna
seeing
put
your
yours up.
highlights.
I thought you were gonna put yours up, that's
I
why.
have mine up, but I don't need the highlights. You did that for the viewers,
Oh,
right?
I thought we were switching and you were gonna put yours up. Alright, we're keeping mine up, then it didn't
Yes,
matter, you're
ma'am.
right.
Correct,
Okay.
ma'am. Correct.
All right, so I'll keep reading. After Celebrate completely rid itself of the 2:27:40 a.m. search artifact that is incredibly inconvenient to the theory of the case of the Commonwealth now comes before the court saying the unilateral and unexplained Celebrate quote updates to remove the artifact should control whether the jury hears uh, whether the expert's allowed to testify. So they're basically challenging everything because they're saying he's finding an artifact that doesn't exist. But the defense is like, well, it existed when Celebrate found it the first time. So that's a question for the jury, not a question of his methodology or his credentials, and not a Daubert issue whatsoever. Um, so
Wait, so I don't did we go through I don't know that we've gone through the Commonwealth's motion for the asking for this particular hearing. Is their point is that he's moot because that no longer exists in the Cellubrite extraction?
no, they're saying that his opinion is bullshit. It's been debunked. His methodology is no good because he's relying on an outdated
That sounds like
forensic
moot.
tools.
It's moot.
Not moot.
It's moot. It doesn't exist. So his
Well,
opinion as to it is moot. That's what they're arguing? Hmm,
well,
okay.
no, they're arguing that he used out. All right, whatever. It's moot.
It sounds moot to me.
All right, so go ahead. You read the first section here.
Okay, so the case history. Okay. So the case history of digital forensic analysis of the 22740 AM search artifact. For 3 years in this case, there has been no dispute over the methodology employed by the defense to address the issue of the 22740 AM search artifact. On June 21st of 2024, Richard Green testified at trial as a defense expert without any objection as to his qualifications or methodology. The use of digital forensics tools to analyze data on the raw image file. As he stated in that testimony, after reviewing the raw image file of the data contained on Jennifer McCabe's iPhone 11, Mr. Green used 5 digital forensic tools to evaluate and analyze the data on the image file. Cellubrite Physical Analyzer, Magnet Axiom, Belkasoft X, Sanderson Forensics, SQ Light Forensic Explorer, and ArtX. So, and then they cite the stuff there. So through the use of these 5 tools, Mr. Green found that the 22740 AM search artifact existed and appeared in a deleted state. Again, citations. Those findings were consistent with the April 24th, 2023 report of Trooper Nicholas Guarino, who testified as a proffered expert of the Commonwealth in the first trial. Mr. Guarino reported that while the 22740 AM search artifact did not appear on the version of Cellubrite Physical Analyzer, which he cites which one he used, which version he used, that he had used for his May 4th, 2022 analysis of Jennifer McCabe's iPhone data. Mr. Green had used the then newest version of the physical analyzer, which did depict the 22740 search artifact, which did depict the 22740 AM search artifact. The newest version was able to pull an artifact in the browser state DB wall file, How Long to Die in the Cold at 22740 AM on 129 of 2022, deleted. Inexplicably and unexplained to this day, Trooper Guarino did not disclose in his report of April 23rd that the Axiom program he had used at that time did show the 22740 AM search artifact. and then you see his defendant's opposition exhibit 1. Do they attach those? Do you know? Babe? Hello? Hello? Can you guys hear me? Allison? Hello? Is Allison
What
frozen?
is going on?
Wow. There she goes. Bye. All right, I'll keep reading. All right, so Mr. Green's findings were further consistent across all 5 tools that he employed. See Green's affidavit. And remain consistent with the findings of as of January 25 from the analyses performed in the most recent version of Axiom, which continues to report the 2:27:40 a.m. search artifacts. See January 25 Green affidavit at 7. Like Mr. Green, Mr. Whiffin's methodology was to use digital forensic tools. Did you hear me? Do they have the exhibits? I can't hear you. Oh, Allie. Wait, hold on. I've been waiting to do this. It's right there. You're tapping on it.
I'll
See,
Oh, okay.
there you go. There you go. Wow. Did you see how Allie was muted, y'all?
Yeah, but
That
that
is
wasn't because I forgot. It was because I
Oh, what really?
was
Really?
Bob, you're muted.
Oh,
Bob, you're muted. I assumed it cut out because I lost everything. Bob, you're
now
muted. Can you
well,
turn that thing off? Bob, you're
you were
muted.
definitely frozen.
Bob, you're I was?
Yeah, you were frozen.
I think we probably both were to
I
them.
wasn't frozen. I don't think so. I don't know. I don't know if I was.
Um, that's gotta be Mandy reminding you as you always remind her.
What? That we're on a
It's
loop?
a
Yeah,
loop.
I meant to play it on a loop for all the
Yeah.
times that you've played it for me. So now you know that's a tricky little if you tap that bar on that mic, it mutes it.
I knew that, I just didn't know where. I thought it was like, where is it here? Is it down here? Is it down there?
I have multiple ways to mute myself, so, that's not good. Alright, so like Mr. Green, Mr. Whiffin's methodology was
Wait,
to
I don't
use
have it back up
Oh.
because I got booted completely out.
Oh, you did?
Yeah.
Oh.
That's why I thought maybe they couldn't hear all of us, both of us for a hot minute, but all right, go
Mm.
ahead.
Okay, so I'm on 6. Okay, yeah. So, like Mr. Green, Mr. Whiffin's methodology was to use digital forensic tools to analyze the raw image file of data from Jennifer McCabe's iPhone. Unlike Mr. Green, however, Mr. Whiffin used only 2 digital forensic tools in his analysis of the data. So, Cellubrite Physical Analyzer, his company's tools, and ArtX. So, and you can see Commonwealth's Exhibit 1 for that. After performing an analysis using a then on market Cellubrite physical analyzer program, Mr. Whiffin testified at the first trial and reported that he had seen the 2:27:40 a.m. search artifact. So, and then that's his testimony. He says, quote, so the 2:27:40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. So that again is coming from his testimony at trial. So then depicting the 2:27:40 a.m. search artifact. Thus, while he disagreed with Mr. Green's opinion about whether that information indicated a search for the quote house long to die in cold end quote was conducted at 2:27:40 a.m., he did not dispute that this 2:27:40 a.m. search artifact was present and in a deleted state during his analysis.
So that just goes to what we were saying earlier about it becoming a question of weight, and for the jury to decide, not a question of admissibility, like that his methodology is somehow flawed because he found this thing that doesn't exist
Yes.
because it did exist.
Yeah, I mean,
What
what
it
we can
means is what's up for debate, and that's an opinion. That's not a Daubert issue.
exactly. It's a fact for the jury to decide whether or not, you know, they believe it or they don't believe it. That's up to them. It's not a Daubert issue. I agree. It's the exact same thing that went on with Dr. Russell. Exact same shit. So, but what this does tell us, what we can glean from this is that they have not taken my advice and they're going full bore into the whole goddamn conspiracy thing again, which I think is a mistake. I'm putting it on record. I am putting it on record. This is a reasonable doubt case. The state, or the Commonwealth rather, has not shown me during that entire first trial any evidence that John O'Keefe was struck by that vehicle, either by accident or on purpose. Period. I have not seen that evidence beyond a reasonable doubt. That's where this case should be won, but I digress. So, I guess, like, people just love that conspiracy shit. Like, if you care about Karen Reed being found not guilty, you should completely abandon this whole goddamn conspiracy thing. It's crazy. Like, you're never convincing 12 people of it. Every time that we do a live on this, I'm going to keep beating that over your guys' heads because it's true.
I
It
think that we
is
somewhat
true.
agreed that they need a abbreviated
There could be elements of it.
version of
There could,
right.
yes, there could be, definitely they could have elements of it, but that's not what this is, dude. This is way more than elements of it. This is the whole thing. All right. So Jennifer Hyde also employed this methodology, originally using Cellubrite Physical Analyzer, Sanderson, Forensics, SQ Axiom, ArtX, and iLeap. She added one. Um, Four of these tools were amongst the five used by Mr. Green in his analysis. In her May 2023 report and in her testimony at trial, Miss Hyde agreed with Mr. Green and Mr. Whiffen that she had seen the 2:27:40 a.m. search artifact during her analysis. Quote, in the instance of the Google search, quote, house long to die in the cold that was recovered with the timestamp of 2:27:40 a.m. was marked by Cellubrite as having this timestamp and being deleted. Emphasis added. She also admitted in her 2023 report that the 2:27 a.m. search artifact appeared in a deleted state. She disagreed with Mr. Green's opinion about whether this information indicated that a search for house long to die in the cold was conducted at 2:27:40 a.m. But she did not dispute that the 2:27:40 a.m. search artifact was present during her analysis.
So again, they're highlighting the fact that this is opinion based and
Totally.
it's not a Daubert issue.
Right. They're not attacking his methodology and his ability to be able to analyze data like this. They're not saying what he did is junk, that it's
They're saying
worthless.
his interpretation is wrong.
Correct, which is up to the jury to decide as a trier of fact. So inexplicably, Mrs. Hyde changed her analysis and findings from her May of 2023 report to align with Mr. Whiffen after a Cellubrite manipulated update to one physical analyzer program, uh, Insignettes, I don't know what that is, which the defense learned about approximately 1 week before trial began. Magically, quote, removed the 2:27:40 timestamp value from records sourced from the Safari's browser state .db, end quote. So using only this, quote, updated, end quote, Cellubrite tool and no others, Miss Hyde drafted a new report in December of 2024, taking back without explanation her original conclusion that the artifact containing the 2:27:40 timestamp was present on the iPhone of Jennifer McCabe in a deleted state. She opined instead that the artifact containing the 2:27:40 timestamp was not present in a deleted state or otherwise, citing merely an unsupported, conclusory, and scientifically insufficient assertion that the timestamp was, quote, not reliable, end quote. One. Like Mr. Whiffen, neither Miss Hyde nor the Commonwealth explain how the, quote, update, end quote, occurred or any scientific reason for the change. The Commonwealth simply makes the same bald, conclusory statement as Miss Hyde. That, quote, further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown, end quote. So the Commonwealth provides no explanation for that assertion, nor Does it provide any information as to the reasons why that supposed research allegedly finds the 7 a.m. search artifact and this artifact alone to be unreliable? It also provides no information about the methodology of that research or any other information regarding what changes were made, how, or why. Wow. So, I mean, what they did, so they created a newer version and they made sure to have this version make it so that that kind of shit doesn't show up anymore. Is that essentially what they did?
Yeah, and what I've said is my official opinion is that I just don't feel educated enough to fully believe this, theory of the defense that this was done for the sole purpose of this case.
That
Like,
seems crazy. That's a bad business model, right?
well, the argument is that they've got to keep their police happy because,
It's
but
making
yeah,
their job tougher. More data can lead to breaks
well,
in
no, because they
cases.
don't need to use Celebrate. They can all start using something else.
I think people do use other shit. Like I
Primarily police departments, I've never seen them use anything other that I have gotten data from has always been Celebrate and the FBI as well. I don't know if that's changed. I haven't gotten any from the FBI in a couple years, but I've always seen Celebrate.
yeah. Yeah, I think there's been a little bit of a shift, to be honest with you. Like, and that came out during Allen's trial. I mean, even the geniuses over at the Indiana State Police started using some different stuff, kind of shifting away from Cellubrite. So I don't know. So critically, despite the manipulation associated with this unexplained update and the accompanying sudden change in the analysis of the Commonwealth's proffered experts, Ms. Hyde's second report, dated December of 2024, does not represent a different methodology, but rather a narrowing of and a change in opinion about the presence of the 22740 AM search artifact. In the second report, she employs the same methodology as she did in the first trial, and Mr. Green and Mr. Whiffen employed but deletes mention of an inconvenient axiom tool she used in her May 2023 report, which, as of the date of this opposition, continues to show the artifact containing the 22740 AM stamp in a deleted state to reach a different conclusion. The only
Right.
difference, in fact, between the application of the methodology by the Commonwealth's proffered experts and the application of the methodology by Richard Green is that the former is entirely encompassed by the latter. Mr. Green simply used more tools in employing the exact same methodology and thus was able to conduct a more thorough forensic data analysis. The appropriateness and reliability of Mr. Green's all-encompassing methodology is evidenced by the fact that all experts agree and opined at some point during the first trial that that 22740 AM search artifact existed and appeared in a deleted state. Mr. Green's methodology is further supported by Jessica Hyde's testimony that it's, quote, it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis. So,
And that's what they're, by the way, calling her admonishment, that was like that she admonished that it's better to use more tools, and that's the best practices.
right. Yeah. I mean, look, we're 8 pages into this, and I'm assuming that the wherefore clause is like, look, judge, we don't even need a Daubert. I just explained to you why. Like the
That's
difference
what they
of
started with too, and there's
yeah.
no affidavit, there's other
Right,
insufficiencies
it's
on the
just
case.
like the shit with Dr. Russell.
And she shouldn't hold a hearing for this. She shouldn't. She probably shouldn't have for Russell either, but, she
Now that she has the benefit of knowing that he brought no receipts, nothing to that hearing to challenge the methodology other than him saying that I think it's bullshit, she should know he's doing the exact same thing here.
and he's right. He's wasting the lawyer's time that's better focused on preparing for the defense.
Yes. And that doing so is quote, absolutely pertinent and allows her to, quote, to ensure that she's getting the most complete interpretations, end quote. This mimics the approach of Dr. Green and is counter to the myopic and company biased approach of Mr. Whiffen, to which Miss Hyde now disquietingly has morphed. The experts' disagreement is not over the methodology, but rather their opinions on whether the 227:40 a.m. search artifact indicates that Jennifer McCabe conducted a search for House Long to Die in the Cold at or before 227:40 a.m. Contrary to the assertion of the Commonwealth, this is a paradigmatic battle of the experts.
And that's essentially the whole crux of their opinion, the primary crux, which is why we've been sort of pausing to point out what they're arguing here is about what the opinion means and, what the artifact means, not whether he appropriately determined an artifact even existed. Although they
Right.
are trying to say he's not appropriately determining it because it's been updated by Celebrate and it's not there anymore, which I would hope the judge would call bullshit on, like, right away.
Yeah. Yeah. All right, you can read a couple pages.
All right.
I'm gonna take a nice drink of water, maybe have an on.
Yeah, there's no water up here. I'm screwed.
I'll bring you some water while you're reading.
Ah. All
Oh,
right. So
I love you.
argument.
All
I
right.
love you.
All right.
1, the court should deny the Commonwealth's request to exclude Richard Green's testimony concerning the 227:40 a.m. search artifact. A, the motion of the Commonwealth is deficient on its face. The Commonwealth's motion to exclude certain expert testimony of Richard Green is deficient on its face in two aspects of Daubert application to this motion. The Commonwealth claims that Mr. Green is not qualified and that his methodology is unreliable, but provides no explanation as to why. In fact, the Commonwealth doesn't even describe the methodology of Mr. Green, which it asserts is unreliable and seeks to exclude. The Commonwealth motion is not only bereft with respect to two apt prongs of the Daubert inquiry, qualifications and reliability of methodology, but also with respect to other aspects of its analysis. Nowhere in the motion does the Commonwealth discuss the general acceptance precept of Commonwealth v. Davis or the 5 non exclusive factors of Daubert. And we cite a Massachusetts case of Davis. What little the Commonwealth does say about the law is route. It's basically baseless, worthless, unsupported, and does not address the question at issue here. The Commonwealth also fails to mention that in Commonwealth v. Rintala instructs that the crucial inquiry for Daubert purposes is whether the proffered expert is qualified. Mr. Green overwhelmingly satisfies that standard. And the motion of the Commonwealth is not supported by any affidavit. See Massachusetts Rule of Criminal Procedure 13.2. I read it earlier. The entire important aspect is cited here. An affidavit detailing all facts relied upon in support of the motion and signed by a person with knowledge of the factual basis of the motion shall be attached to all pretrial motions. I did do some other research into this as well. The courts are able to summarily dismiss or deny a motion for not having the affidavit, um, and not even grant an evidentiary hearing. The defense goes on to say the Commonwealth additionally misses the point of a Daubert inquiry. It argues, for example, that Mr. Green's opinions as to the artifact containing the 227:40 a.m. timestamp, quote, lacked any evidentiary support, quote, cannot be made in good faith, constitutes, quote, baseless claims, and have been, quote, debunked. These claims, in addition to being false, have no relevance to the methodology inquiry. They relate only to cross examination and jury determinations. Again, pointing out that this is not a Daubert issue. This is not a gatekeeper function issue. This is a question of whether or not they believe the ultimate opinion of this expert who used sound methodology, who is, of course, um, qualified, if his opinion's accurate. And that's not a gatekeeping function. And if it's reliable, but saying that there's a dispute to reliability does not make one's expert unreliable. And again, we saw that with the dog bite expert. B, even if the motion of the Commonwealth was not deficient on its face, Mr. Green easily meets the requirements of Daubert. Broadly, the Daubert inquiry involves evaluation of both qualifications and methodology of the proffered expert. They quote a Massachusetts case. However, the crucial issue in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. In addition, under Daubert, the judge, acting as gatekeeper, is responsible for making a preliminary assessment whether the theory or methodology underlying the proposed testimony is sufficiently reliable to reach the trier of fact. And they cite Commonwealth v. Camblin. In making that assertion, the court may consider, and this is a quote from that case, whether the scientific theory or process, 1, has been generally accepted in the relevant scientific community, 2, has been or can be subject to testing, 3, has been subjected to peer review and publication, 4, has an acceptably high known or potential rate of error, and 5, is governed by recognized standards. When applying this standard, the judge must be careful not to invade the province of the jury. Again, that's the crux of this entire motion. That's what a jury is to decide, not what a judge says they can't even hear. They go on to say, critically, it is the qualification and methodology of the expert, not their conclusions, which the judge is tasked with evaluating. And they cite Camblin too. Differences of opinions present issues of credibility, which are properly reserved for the jury. They cite Ribeiro for the and quote there, once the expert's qualifications were established and assuming the expert's testimony meet the standards of Commonwealth v. Langian, which is their adaptation or adoption of Daubert. The issue of credibility was for a jury, not the judge. Accordingly, quote, expert witness testimony should not be deemed unreliable simply because there is a disagreement of opinion or in the level of confidence among the experts. They also cite Rule 702, which is an adoption of the federal rules for expert testimony. Or because the judge disagrees with the expert's opinion or finds the testimony unpersuasive. Again, citing Ribeiro. Such disagreements make up the battle of the experts. Again, very sound, very established arguments in case law. This should be a no-brainer, but
Hey, you didn't put your thing up here.
oh,
What's wrong with you?
oh,
What's that up?
wait, fix it.
What do you mean? That right?
Mm,
You're set up in a weird position. You're more in the middle of the thing.
well, I always have it where it covers the door so I can come in and out without anybody seeing.
Well, you mean I always have it.
Well, right, you always have it.
So you need to move your seat over.
All right, I'm staying like this. All right. Yeah, that would have been a great time to switch spots, as Spitfire pointed out. I don't know why we didn't. Okay, so now 1 under this B of the first part of the argument is Richard Green's education, training, experience, and familiarity with digital forensics qualify him as an expert on the topic. So now we are going to go through this here. So when we get to Green's affidavit, we're going to skip over his experience and go right to the crux of what he's saying, not like his education and training. As to the critical inquiry of the Daubert standard, the proffered expert's qualifications, Mr. Green clearly satisfies the requirements of the standard. Mr. Green has more than 25 years of experience as a computer forensic technician and more than 18 years of experience conducting electronic data analysis and investigation. Citing to his affidavit, Mr. Green has been accepted as a digital forensic expert approximately 24 times in the United States. Mr. Green was qualified and testified as an expert for the first time in 1996 after spending approximately a decade working in computer information technology and networking, building a line of computers and doing computer repairs. Mr. Green started a digital investigation firm called United States Forensics, which he still owns and operates today. His company handles between approximately 100 to 120 cases per year and receives annual inquiries for about 3 times as many cases. His company has worked on civil and criminal cases across the country in both state and federal courts and on behalf of both, I thought I pressed the mute, and on behalf of both defense teams and law enforcement. Since starting United States Forensics nearly 2 decades ago, Mr. Green has worked full time in digital forensics. In addition to being in addition to being the company's president and founder, he performs the majority of the investigations. He specializes in computer, cell phone, cloud, audio, video, metadata, media, surveillance systems, and other similar systems. Mr. Green has significant education, training, and experience in the field of digital forensics. He holds an associate's degree in digital forensics and computer investigation. He is a certified computer examiner, CCE, with the International Association of Criminal Investigation Specialists, and he also holds computer-related criminal investigator, cybersecurity, and computer forensic first responder certifications. He's also a member of 4 professional associations in the field of digital forensics and was the keynote speaker on electronic data forensics at National Association of Legal Investigators 2008 Midwinter Conference. Over the last 18 years of full-time work in digital forensics, Mr. Green has received daily on-the-job training. Namely, in addition to work he does every day at his company, he has participated in list servers, conducted research into the newest developments in digital forensics, and attended training seminars approximately once per week. Okay, so that's some continuing education on his part. I'd like to see what their officers' reconstruction, how much continuing education he was getting. In total, he has participated in hundreds of training events offered by software companies who provide the digital forensic tools used by experts in this case, including Celebrite, Magnet Forensics, and Belkasoft. Mr. Green has attended 67 of these trainings, not inclusive of many of the web training sources that Mr. Green follows on a continual basis since 2022. Notably, Mr. Green has attended trainings hosted by Celebrite and Magnet Forensic every year for the last 3 consecutive years, and by Belkasoft in both of the last 2 years. His affidavit accompanying this opposition affirms his broad and deep qualifications. On December 31st, 2024, despite Mr. Green's robust digital forensic credentials and experience, the Commonwealth moved to exclude the proposed testimony of Mr. Green as to the 2027 40 AM search affidavit. The Commonwealth's motion should be denied. The education, training, and experience described by Mr. Green is not only overwhelming in its own right, but also much more significant than that of the proffered prosecution expert Ian Whiffen. According to his own testimony, Mr. Whiffen has testified in the United States only once in his entire career in Michigan. Whiffen also admitted at trial that, unlike Mr. Green, he has, quote, no specific certifications in digital forensics other than a higher national certificate in computing, and does not have a degree in digital forensics or otherwise. By proffering Mr. Whiffen as an expert witness, the Commonwealth has tacitly affirmed its belief that Mr. Whiffen is qualified. Accordingly, the Commonwealth's argument regarding Mr. Green's qualifications should be rejected. Like they're saying, okay, call bullshit on qualifications. They're saying their guy is qualified for having an ounce of the qualifications that the defense expert has. So come on. Come on. And they're right. Absolutely right. Undoubtedly, undeniably right, in my opinion. Contrary to the Commonwealth's contention in their motion, Mr. Green was not, quote, broad and vague during cross examination. Mr. Green answered clearly and completely the only question the Commonwealth asked him about his training, expertise, and certifications. Out of 5 digital forensic tools Mr. Green used to evaluate the data from Jennifer McCabe's iPhone 11, Attorney Lally chose one, Celebrate, and asked Mr. Green if he had a certification for that particular platform. Mr. Green stated clearly, after seeking clarification of the question, that he had no such certification. He added that his certifications are much broader as they concern digital forensic fundamentals, how to conduct investigations, and which tools to use. His answers were specific and appropriately detailed. The Commonwealth's statement is thus incorrect. Now, I find this interesting, and I wonder if the Commonwealth just forgot about these portions of his testimony or are only trying to exclude a small portion or one portion of Green's testimony. So the defense says, curiously, according to the Commonwealth's own argument by admission in this motion, Mr. Green remains qualified and his methodology is reliable in several other areas of data forensics he testified about in the first trial. The Commonwealth challenges none of those several areas of digital forensics, namely the call logs deleted from Jennifer McCabe's phone, the screenshot of the contact for, quote, Uncle Brian A, or Uncle Brian A, deleted from Jennifer McCabe's phone, the location data from Jennifer McCabe's phone, the health data from Jennifer McCabe's phone, the location data from John O'Keefe's phone, and the health data from John O'Keefe's phone. That the Commonwealth does not challenge Mr. Green's qualifications as to those topics is further evidence of his imminent qualifications. Such a challenge would fail, as should this one. Okay. I'm saying you take over 2 here.
Where are you?
Uh,
End of 14?
Page 15, top, it's number 2.
Okay.
Open up the one that has the highlights, so you see when something's highlighted, you know we wanna talk about it.
So are you saying when I get to that portion just to stop so we can chat?
I don't know, do what you want with it. If it prompts you to ask a question or say something.
Okay. So Richard Green's methodology is reliable. The Commonwealth's papers fail to identify a methodology for Mr. Green, let alone state why his methodology is flawed. And in fact, the Commonwealth cannot make such a statement because Mr. Green not only employed the same methodology as the Commonwealth's proffered experts, but expanded upon that methodology by utilizing more tools, performing additional low-level analysis, and examining overall user activity. It's kind of saying the same shit over and over. Who wrote this?
Yes.
Lisi?
Yes.
Okay, so the validity of Mr. Green's methodology is evidenced by the fact that all experts employed it and acknowledged at some point during the first trial that the artifact contained the 2:27:40 a.m. timestamp existed and appeared in a deleted state. Okay. Asked and answered. Asked and answered.
Yes.
Timestamp was correct insofar as it that is the time that is shown within the database. It was indeed a deleted record. In the instance of the Google search, "How Long to Die in the Cold," that was recovered with the timestamp of 2:27:40 a.m. was marked by Celebrate as having this timestamp and deleted. Asked and answered. Nonetheless, the Commonwealth now asserts that Mr. Green's methodology is somehow unreliable. It provides no competent evidence to support this contention. What little support it provides is ipsa dixit assertions for or on issues for the jury and not a Daubert Lanigan inquiry misconstrues the evidence. The Commonwealth claims that Mr. Green admitted that his, quote, misinterpretation of the data, end quote, caused Celebrate to, quote, update, end quote, its physical analyzer program to remove the artifact containing the 2:27:40 a.m. timestamp. But a proper reading of Mr. Green's June 21 testimony transcript makes it clear that the question was poorly stated to the point of incomprehension. Did you highlight that?
I did. I
Okay.
thought I thought you opened up the
No, I didn't. Wow, did you guys hear that? She's like, wow. Wow. I sent it. You didn't open it. All right, I'll open it now.
I mean, I spent the time to do it.
What? You mean email?
No.
Oh, you mean
Review and
highlight it.
highlight important stuff.
Okay. I'll pull it up. Yes, ma'am. Yes, mommy. I'll do it.
And this is just pointing out just generally the type of, shit that the state was doing, the police were doing, like the earlier mention of how the officer just left that out, the fact that he didn't even put it in his report at all, even though it actually did show up and he testified it did show up when he conducted a later search, but he just decided, "You know what?
I didn't get an email from you, babe. Nothing new.
Oh my gosh.
Oh, good lord. It's probably in your outbox. You know how that works.
No," or I sent it to, uh yeah, I sent it to your law firm address, just forget it.
Just forget it. Okay, so in his answer, Mr. Green was making the point that as of June 21, 2024, Celebrite had two contradictory versions of Physical Analyzer on the market. In one version, Insiets, is that how you pronounce that? Insiets, maybe? Physical
Wait, where
Analyzer.
is it? Oh, yeah,
Yeah,
I don't know.
I don't know. The 2:27:40 a.m. search artifact had been removed, while another version, Physical Analyzer 7, still showed the artifact in a deleted state. Beyond that, Mr. Green was simply stating his awareness that Cellubrite sucks, made changes to its software sometime after viewing of the 2:27:40 a.m. search artifact before trial, only on the version of the physical analyzer available to him at the time. This purported, quote, evidence, end quote, of supposed unreliable methodology is not about methodology at all. It is about two Cellulite programs out on the market at the same time that are presenting differently about the 2:27 a.m. search artifact. That is a problem caused by Cellubrite, not Mr. Green. Moreover, the problem is for the jury to determine. It is not a Daubert Lanigan methodology issue. It therefore does not support any basis for exclusion of any portion of Mr. Green's testimony under Daubert and Lanigan. I have to say, and like the dude's not certified in Cellubrite, like, he's just not.
I know,
Like, get a different fucking guy. Like,
right.
why are you, like, dying on the Richard Green hill? Like, again, it
I
it
agree.
it lends to the thinking that they can't find somebody else to say that the goddamn thing was on the phone. Like, when you know that Brendan's gonna be able to go in there and just shit all over this guy because he's not certified on Cellubrite, yet he's making some determination that this appeared in a celluloid extraction, it's not powerful.
But he's reviewing a lot of other,
I
uh
understand.
right,
I
tools
understand.
as well. But, yeah, I do remember thinking, that I mean, I don't know why the, um Commonwealth's ability to attack it appearing on I mean, it in theory, it should work the same way where you're saying to their expert, "So all you know about is Celebrate, but it showed up on this other tool and this other tool." You can't speak to that, right? You can't say whether that how that works and he'd have to answer no.
Yeah. Yeah.
So can't you make the same counter argument that the Commonwealth can only get Celebrate to say it didn't exist?
What is free radical? Is he now certified in Celebrate? Because he wasn't at the first trial. I mean, I would hope that he went and got certified on it, if that's why you're saying that I haven't read the AFI yet, because he definitely was not at the first trial. So I don't know.
Wait for the
Um,
affidavit, you will see.
I'm gonna read the affidavit, and I'm still gonna think that you shouldn't die on the Richard Green Hill.
Well,
That's
wait
my
till we
opinion.
read the affidavit.
Okay. So the Commonwealth also claims that Mr. Green's opinions, quote, lack any evidentiary support and, quote, cannot be made in good faith, end quote, cannot, and they constitute baseless claims. First, contrary to these false and baseless assertions, Mr. Green's opinions are backed by scientific or significant scientific evidence. An NIST scientific foundation review, a digital investigation techniques, and draw on the very same data contained in the raw image file obtained from Miss Jennifer McCabe's iPhone 11, which all three experts relied on. Second, even if these claims were accurate, the purported lack of evidentiary support the Commonwealth alleges would go to weight and credibility of Mr. Green's opinions, not the threshold of whether his methodology is reliable.
And that's the end all and be all for the purposes of this motion.
Right. That's it. Okay. So once the experts' qualifications were established, the issue of credibility was for a jury, not for the judge. Likewise, the Commonwealth claims that Mr. Whiffen performed a comprehensive study of the forensic data and that there is no evidence whatsoever on this device of a search conducted prior to 6:23 a.m. or of deletions. These claims are false. First, Mr. Whiffen did not, emphasis added, perform a comprehensive study because he only looked at limited data, only used two tools, and relied nearly entirely on one, his company's tool. His analysis is certainly less comprehensive than that of Mr. Green, who used five tools, asked and answered. Second, there is, emphasis added, evidence in the raw data from this device of the 22740 AM search artifact and of the deletions. The evidence was found in all five of the forensic tools used by Mr. Green. Now that's interesting. So Green does not have the device, right?
Well, he has a digital image, a forensic image, which
So
is
so he can run that through the other programs the same as
yeah.
if he had the actual device, right?
Yeah, that's why I kept asking why wasn't the defense getting a digital image in, um, Richard Allen? Like, get your forensic image and have your person do their full extraction. I mean, that's what we always do.
Okay. All right.
When it
Yeah.
matters. I mean, sometimes it doesn't matter enough and you're talking about like a text message here or there, but when you're talking about whether a search occurred and what time, whether something was deleted or not, then you have your own expert examine the forensic image, which is basically like the same exact thing. What I did find interesting, and it's in his affidavit, I did not know that they could alter what is transferred in a forensic image. I thought it was literally just like a copy of the entire, thing. And you'll see in the affidavit that they were up to some shady shit that I don't know if I realized the first time around at the first trial that had transpired.
Hmm. Okay. All right. So, okay, this evidence was found in all five of the forensic tools used by Mr. Green, and the most up to date version of Axiom continues to show the 22740 AM search artifact in a deleted state. Notably, Mr. Whiffen qualifies his statement to the contrary with, quote, of the data I examined, end quote. Third, Mr. Whiffen does not mention, let alone account for the several anomalies Mr. Green discusses in his affidavit accompanying this opposition that undercut the entire December 2024 report of Mr. Whiffen. In any event, these claims by Mr. Whiffen are no more than reiterations of his opinions and thus clearly are not a Daubert Lanigan matter, but our
Lanigan.
cross-examination. Huh?
I was like, I was saying it wrong, I think. Lanigan. I don't
Yeah,
know
it's
what I was
definitely
saying.
Lanigan. Were you
Yeah.
saying Langanan?
I don't know.
But our
I see it so
cross-examination and
clearly
jury men.
Lanigan now. I don't remember. We'll have to go back and look at it later. But I stopped saying it and just said I'm calling it Daubert moving forward.
The Commonwealth's claim that Miss Hyde, quote, conducted an encompassing review is similarly false. In fact, most recently, Miss Hyde did exactly the opposite, contravening her own first trial testimony about the importance of using multiple tools. She produced a new report in December of 2024, relying only on the, quote, updated, end quote, Celebrate physical analyzer.
Asked and
Okay.
answered.
Asked and answered. Asked and answered. These phases and claims used by the Commonwealth in its motion are not just incorrect. They further demonstrate a fundamental misunderstanding of Daubert and Lanigan's two core concerns: the province of the judge in a Daubert Lanigan context, and the province of cross-examination and the jury. These are not the only errors the Commonwealth makes in its motion. For instance, the first footnote of the Commonwealth's papers is incorrect, sir. Celebrate is not the leading forensic data extraction software tool. Told you they were. That shit's fallen out of favor, girl. Celebrate is a company, one of the companies that provides one of the digital forensic tools relevant in this case. Emphasis added 2 times. It is clear that the Commonwealth's myopic focus on Celebrate Physical Analyzer is misleading and allows the prosecution to disappear the 2:27:40 a.m. search artifact, despite Jessica Hyde's testimony during the first trial about the absolute pertinence and value of using multiple tools. Asked and answered. The Commonwealth seeks to discredit Mr. Green, who did exactly that while proffering experts who rely almost exclusively on Celebrate Physical Analyzer to perform their analyses. This contradiction sheds light on the undeniable effect of the Commonwealth's motion. Now, discuss only one data forensic tool, Celebrate Physical Analyzer. They manipulate all the Celebrate Physical Analyzer programs through some black box process in the electronic back room of Celebrate. Hey, let's go to the back room here and throw it through the black box. So they no longer show the artifact containing the 2:27:40 a.m. timestamp. And euphemistically, wow, look at that.
Yeah.
Label the mysterious and suspicious process as an update. I mean, they're literally claiming they went back and like fudged all this shit to fuck this case. Then claim Mr. Green is unqualified and his methodology is unreliable simply because he will not play along with the manipulation of the Celebrate Physical Analyzer programs, especially in the light of the Axiom program previously used by the Commonwealth witnesses Guarino and Hyde, still showing the artifact containing the 2:27:40 a.m. timestamp and in deleted state, no less. In addition to the prosecution's newly contrived debunked narrative being false, the debunked parlance in a Daubert Lanigan motion is inappropriate and can be seen as an improper attempt to garner media headlines and otherwise prejudice future jury pools. Ooh.
Yeah, so that got an orange highlight. Just because that's basically the end all be all, of what they're saying, you know. And again, I before you got on here went on the record
Thanks for that
multiple
comment, Veta. Appreciate that.
I went on multiple times I went on the record as saying I just don't know that I'm willing to accept um that the Commonwealth, I mean the defense's opinion of that, like that they went back and did this just to debunk this, and I also said I'm not 100% saying I I'm never gonna agree with it. I need to be more educated technologically, scientifically.
You know what we need? You know what you and I are gonna do? We're going to find the best goddamn phone forensic guy on the planet or gal, whatever the case may be, and we're gonna bring him on this show because I want somebody that's not involved in this case explaining what the hell is what.
I tried to call one of the experts we've used before, but
I'm gonna
they're
sneak in to somebody's office and pimp the extraction, the digital extraction, and then have our person run it through and then give us a great explanation. So none of that will happen other than the fact that I will try to find some kind of expert to come on and explain it. All right. So, A, Mr. Green's methodology is generally accepted in the relevant scientific community such that this court need not reach the 5 non-exclusive Daubert-Lanigan factors. So, Mr. Green's methodology was employed by the Commonwealth experts in this case, and it is supported by relevant digital forensics literature on best practices from the National Institute of Standards and Technology. Okay, there's the Digital Investigation Techniques, a NIST scientific foundation review. As a result, Mr. Green's methodology is properly regarded as generally accepted in the relevant scientific community. Under Commonwealth v. Davis, this general acceptance by the relevant scientific community is sufficient. Therefore, pursuant to Davis, this court need not reach the 5 non-exclusive Daubert-Lanigan factors. The issue of the 227As, okay, should reach the jury. Asked and answered. B, even if this court reaches the 5 non-exclusive Daubert-Lanigan factors, Mr. Green satisfies them. Because general acceptance of Mr. Green's methodology by the relevant scientific community is sufficiently well established, this court need not reach the Daubert-Lanigan factors. However, if the court reaches those 5 non-exclusive factors, Mr. Green's methodology satisfies Daubert-Lanigan precepts.
So I just wanna say, this attorney, my understanding is that he is, does a lot of
Alisi?
appellate work,
Yep.
right? He's an appellate attorney.
Mhm.
This is almost how you have to do it with an appellate court. You can't just say it in the introduction, and then they're gonna say, "No, no, 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 no. You did not flesh this out in the body.
Gotta
You
flesh
didn't
it out.
you didn't say it again." And I have been dinged, danged, dung, I don't know.
Ding, dang,
Um,
dong.
right, even for, like, kinda see above, like, no, they want the whole damn thing said again. So, although, it's not your typical writing style in state court, it's what the appellate courts want to see, because then you get told later, well, in your motion you glossed over this, you didn't flesh it out even in the state court, so you know it's waived. But most assuredly if you do it in the appellate court. So while, yeah, we're noting that this is, asked and answered, we're not saying that it's not an
Duplicative?
no, I'm just saying it's not a
Duplicative?
indictment. No, an indictment on this lawyer's
It's very
legal,
duplicative. I get it. I get it. It's still duplicative.
but it
So,
needs that's the way appellate lawyers
I
write
get
things.
it.
That's what the appellate courts
You're
want.
saying it's a necessary evil is what you're saying. So again, as to the first factor, Mr. Green's methodology is generally accepted in the relevant scientific, i.e. data forensics community and indeed by the Commonwealth's proffered data forensics experts themselves. So I'm going to skip that whole
Oh,
the
wow.
NIST scientific. So as to the second factor, the methodology and the tools used
Wait,
are
did you go down to the
to what?
oh. Oh, I thought you were just gonna skip over
No,
this
I'm reading it all.
whole okay.
So, as of the second factor, the methodology and the tools used are regularly subjected to testing both by the experts who use them and the companies who provide them. This regular testing is made apparent by the many legitimate, emphasis added, updates and improvements. little, that's a little snark there, kids. That emphasis, legitimate. He's saying that whatever they did in
Yeah,
the
they
back
all get
room
it.
there. Oh, okay.
They heard
Updates
it.
and improvements made to the tools by their respective companies, which result in the periodic release of new versions of these tools. Third, while, quote, the methods used in digital forensic investigations are often not peer reviewed in a formal process, trustworthiness is established by members of the digital forensic community trying out proposed methods, testing and circulating updates within the community, end quote. Because this testing of digital forensic tools takes the place of peer review in the digital forensic field, it is therefore sufficient to for purposes of a Daubert Lanigan analysis, which, quote, must be flexible, end quote, and which, quote, must or may require judges to apply differing evaluative criteria, end quote, for different methodologies. Fourth, the methodology also does not have an acceptably high known or potential error rate. The Commonwealth's own proffered experts endorse and employ this methodology as scientifically sound, reliable, and accurate. Finally, the methodology is governed by recognized standards. Okay, and there's good old NIST again. All the proffered data forensic experts in this case are using the same methodology and in various instances at various times using the same or similar data forensic tools. Asked and answered. In all events, the Daubert Lanigan factors are non exclusive, so no factor is dispositive. Okay, not all the factors identified in Daubert will be applicable in every case. A trial judge accordingly has broad discretion to determine how to assess the reliability of expert testimony. Because Mr. Green is qualified and his methodology is reliable, the court must deny the Commonwealth's motion. On the papers, please. On the papers. We need not come into your court of law, ma'am. All right. Two, the Commonwealth has shown that an evidentiary hearing has not shown that an evidentiary hearing is required. Daubert Lanigan evidentiary hearings are canceled in Massachusetts once papers in the opposition to the request for such hearings are filed, demonstrating the lack of a need for hearings. Affirming the judges, so there's Commonwealth v. Addy, affirming the judge's decision made on the basis of the parties' papers and arguments, not to hold an evidentiary hearing and to admit the expert's testimony. This is another case that fits under that proposition. The core concern of Daubert Lanigan standard is promoting reliability by ensuring an expert has sufficient qualifications and employs a reliable methodology. This opposition establishes Mr. Green's eminent qualifications on the subject matter in dispute and the reliability of his methodology. The Commonwealth's bare and conclusory assertions, those are bare and conclusory assertions, sir. To the contrary.
Bob was just recording a podcast.
Yeah. Well, plus I'm in a good mood because you know I'm always in a good mood when I finish a Garcia. Are to the contrary, are insufficient to warrant an evidentiary hearing on the issue of the artifact containing the 2:27:40 a.m. timestamp. The Commonwealth's motion appears to stem not from a genuine dispute over Mr. Green's qualifications and methodology, but from its transparent and disquieting campaign to deny Miss Reed the ability to present. You all right there, babe? Aw, I wish I could give you a little pat on the back, a little cough pat. Miss Reed the ability to present her own defense through her own qualified and reliable witnesses to prevent the ultimate jury from receiving and evaluating evidence that is harmful to and inconsistent with the Commonwealth's theory of the case, and to drain Miss Reed of her resources in advance of trial in the process, which is ample. She's got like a huge amount of dough in that GoFundMe. By submitting conclusory and insufficient motions under the guise of Daubert Lanigan, the Commonwealth seeks to force the defense to repeatedly participate in unnecessary motions and attendant resource-intensive mini-trials, thereby needlessly expending limited defense resources and diverting them from trial preparation. I love that argument. I literally just made that argument in today's episode that I recorded of. You're muted. Hold on. Wait, I gotta get the thing. Hold on.
Yes, of course, because they did the exact. No, you can't do it now. It's too late.
Bob, you're muted.
Because they did the exact same thing in Garcia with complete bullshit.
Bullshit.
And just got to. And the other argument they made to like put this into the public sphere.
Yeah, in Garcia, they're just getting ready to launch Allison into the atmosphere. Shoot her right out of Omaha. She gone. By submitting conclusory and insufficient motions under the guise of, wait, did I already read that? The Commonwealth seeks to force the defense to repeatedly participate. Oh, yeah, I read this. Participate in unnecessary motions and attendant resource intensive mini trials, thereby needlessly expending limited defense resources and diverting them from trial prep. Through this misuse of Daubert Lanigan, the Commonwealth also effectively is obtaining depositions of defense expert witnesses, including the attempted locking in under oath of their testimony for use at trial. This instant motion and others like it are tantamount to legal tyranny, not a search for truth and justice.
Oh God.
All allowing the Commonwealth's motion to exclude Mr. Green would not only sanction this misguided and disturbing approach, but also the impermissible and intolerable adverse jurisprudential consequences of the Commonwealth's actions, which would extend beyond the instant case. Allowing the Commonwealth's motion would set a precedent that when the Commonwealth does not like a proffered expert's opinion, it may file rote, vague, legally insufficient, and vexatious Daubert Lanigan motions to exclude that proffered expert, and most important, the evidence associated with the expert. That is, the Commonwealth will make Orwellian unpersons of the evidence, which is problematic for its theory. I'll tell you what, I love Elise's writing style, though. He's Baldwin-esque. The danger of this approach by the Commonwealth and the precedent it would set cannot be overstated and respectfully should not be countenanced by this court. For these reasons, the Commonwealth's motion, along with its included request for an evidentiary hearing, must be denied.
All right, pull up the affidavit. I'll read the conclusion. For the reasons above, Ms. Reed respectfully requests this honorable court deny the Commonwealth's motion to exclude certain testimony of defense witness Richard Green and its included request for an evidentiary hearing.
All right. There we go. I got it up, babe. I got it up.
I got to remove mine.
Oh, you want me to pull it up on mine? All right.
Oh.
No, that's cool. That's cool in the game. Can do, babe. Can do. Boop. Look at that. Thing's pristine. The affidavit of Dick Green in support of defendant's opposition to Commonwealth's motion to exclude certain testimony of defense witness Dick Green.
What? I just want to ask everybody, where is it? Because I was saying that we should skip paragraphs 1 through 8.
1 through 8. Well,
because they went through, they summarized all this training, but we can touch on where all of his training and celebrate.
Yeah, so paragraph 1, it's, all based on his personal knowledge. He's the owner of President of the United States Forensics. He's got 25 years of experience as a computer forensics tech.
I know, but we read all this in the motion.
Like that? I didn't remember. Oh, like early before I came on?
You might have been coming to get me a drink. I said at the time, look, we're going to read this now, so we're going to skip over the education.
Okay.
But if you go down to 4, just note there, you can highlight all the places it says he's got training and celebrate.
Okay.
He's got training at B.
So B,
W and X.
W and X. A lot of training with magnets.
SSTT and UU.
SSTT, UU, Cell Hawk, which
All
is
right,
like the distant brother of Celia Bright. A lot of magnet shit he did, huh?
Right. And now.
All right. So dude's had a shit ton of training. All right. So we got that out. Like that's knocked right out, right? It's got a lot of important. Yeah. Something is so funny, Anti-Bev. It is important, but I mean, we can see it. He's got a lot of training. I don't think we literally need to read all of it. A lot of magnet, a lot of Celebrate, some Cell Hawk. And there you go. I think I feel good with it. He's well trained. All right. So initial data production. So USF was initially provided with the Cellebrite UFED report prepared by Nick Garino with Massachusetts State Police, the Staties, which was labeled full file system extraction of an iPhone 11 belonging to Jennifer McCabe. In the initial report prepared by Guarino, the 2:27 a.m. search for House Long to Die in the Cold did not appear. Recognizes that this report was not the best evidence. I personally requested the image file for the phone in question, which I had reason to believe was produced using the Gray Key product based on the naming convention contained within the Cellebrite report. 10. I subsequently received a USB drive containing a forensic image of the iPhone 11, described as J. McCabe, belonging to Jennifer McCabe, which was forensically imaged by the Massachusetts State Police using a tool known as Gray Key. The USB drive containing the forensic image was sent to USF by Assistant District Attorney Adam Lally with the Norfolk County District Attorney's Office by way of Guarino with the Massachusetts State Police. Wordy, very wordy.
All right,
Upon receipt, yes,
I just
yes.
gotta pipe in here. I've gotta get Scarlett to volleyball. Your aunt and uncle are here,
Oh boy,
so I'll go keep them occupied while you
shit's
wrap this
popping.
up.
Shit's popping. All right.
All
Okay.
right. Bye, everybody.
Love you, babe.
Oh, I can't really leave. I'm just gonna remove myself because I started this. So
You started it. That means that you can end it. She gone. All right. So the USB drive containing the forensic image was sent to the USF by Lally through Guarino. Upon receipt, the USB containing the image of McCabe's cell phone was assigned to an internal evidence number with the USF. So that's the number right there for you. Notably, the USB drive containing the forensic image of Jennifer McCabe's cell phone failed to include the associated documentation containing the hash value, which is a well-known mechanism used to validate the data and ensure that it has not been changed or otherwise been manipulated. After personally insisting that the state police provide the staties provide the hash value associated with this data, USF was eventually provided with a PDF containing the purported hash value, and the value listed within that PDF matched the Gray Key image file of the cell phone in question. So, after obtaining the full file system extraction of the data contained on McCabe's phone, the data images were processed and reviewed with the Cellebrite Physical Analyzer version 7.61.0.12 and Axiom version 6.11. So, opinion one, it is my opinion, based on a reasonable degree of certain scientific certainty, that the user of Jen McCabe's cell phone searched House Long to Die in the Cold at or before 2:27:40 a.m. It is my professional experience. This is what I've been waiting for, kids. This paragraph right here is what I've been waiting for years to read this. It is my professional experience, an analysis of a device's internet search history often gives valuable clues as to the user's intent or knowledge surrounding an incident. I conducted a review of the search history information obtained from Jennifer McCabe's iPhone 11 and observed the following significant artifact from the morning in question, as reported by Cellebrite Physical Analyzer V7 and Axiom V6. Search term, okay, which were the most recent versions of the respective tools at the time I conducted my initial analysis. Search term, House Long to Die in the Cold. Last viewed date and time, 1/29/2022, 2:27:40 a.m. URL, Google search House Long to Die in Cold. Use Safari. Source, Safari suspended state tab. State, deleted. Type, WAL, wall. 13, Cellebrite processing. In Cellebrite Physical Analyzer V7, the 2:27:40 a.m. House Long to Die in the Cold search not only showed up in the web history, but Cellebrite further refined the results and included it in the searched items artifact section. It was marked as deleted. as a deleted record with an adjusted last viewed timestamp of January 29th, 2022 at 2:27:40 a.m. Noting the inconsistencies in Cellebrite's reporting between the UFED report generated by V7 and Cellebrite's physical analyzer V7.61, I contacted Cellebrite's technical support to inquire if they could provide additional information about this artifact. Cellebrite's technical support staff, oh, this is getting juicy. This is getting juicy right here. Get a little juice. All right, I contacted Cellebrite's technical support to inquire if they could provide additional information about this artifact. Their support staff indicated that they believe that the artifact was reliable and that no issues had been brought to their attention. On April 22nd of 2024, the Commonwealth's expert Ian Whiffen emailed me stating, "Hey man, the last visited time, end quote, shown in PA will be getting removed from the artifact in the next available version of Physical Analyzer after the start of trial." What? Say, hey, you know that thing that you found? Well, we're going to remove that fuckface. How you like that? How you like that? How you like that? So Whiffen hits him up in an email. I hope the email is attached somewhere, right? So, hey, by the way, that thing that you found, we're removing it. It's not going to be there anymore. Yeah. I've never heard of one expert calling another expert and laying wood to him. Wow. That's not a good look. Not a good look there. Whiffin. Wow. That's crazy. That's crazy. Why didn't that come up at the first trial? Anybody know? Why didn't that get raised at trial? That's kind of like smoking gun shit to me. After the start of this trial in late May, Cellebrite released Inseyets. Who came up with that name? Because it sucks. Can barely even read that word. Inseyets? Like, why? Why that word? Is that a word? Somebody in the chat, let me know if that's actually a word. Okay. Physical Analyzer, which removed the 2:27 a.m. timestamp from its processing of the artifact. Shortly after trial on July 22nd of 2024, Cellebrite released its Cellebrite Physical Analyzer Standard V7.69, which also removed the 2:27 a.m. timestamp from its processing of the artifact. Notably, Cellebrite is a company that markets itself as providing, quote, digital intelligence solutions for law enforcement, end quote, and is used by over 6,900 public safety agencies in over 100 countries worldwide. Although I am aware that Cellebrite recently changed its analyzer programs so that it no longer reports on the timestamp of this particular artifact, I have not misinterpreted the data. So the inference there is pretty clear. I mean, they're essentially saying, Green is saying, or in whoever helped him draft this, which I'm assuming is Elise, which is, there's nothing wrong with that. Nothing wrong with an attorney preparing an affidavit and saying, hey, I need you to review this to make sure it's completely and totally accurate. If so, go ahead and sign off. There's nothing wrong with that, just so you know. Okay. And I'm not assuming that that's what happened, but I'm assuming that's what happened here. So, because I listened to Green talk, like this does, it seems ungreen like the way that this is drafted. It seems more Elise like. Yes. Elise. Yeah, I'm going to wait until shit gets filed, Marissa. We'll see. We'll see. 14, the Axiom processing. Axiom is an application product offered by Magnet Forensic, which, if we remember back to paragraph 8, he had a huge amount of training with Axiom. I'd say it dwarfed the amount of training he's had on Cellebrite. So I would consider him especially to be an Axiom expert. which is a competitor of Cellebrite. So, best practices in digital forensics require forensic examiners to view data and artifacts with more than one tool. That just seems like common sense, right? Seems like common sense to use as many tools as you have at your disposal to make sure that what you're seeing is legitimate. And when this guy uses 5 different tools and they all show the same thing, you have to think that it's legitimate. But to kind of go back to the point that I was making a little bit earlier, like 45 seconds ago, it appears that they're insinuating that Cellebrite, because of who lines their pockets with money, which is, of course, law enforcement, that it would be in that company's best interest to not piss law enforcement off. And I guess the question becomes, can we look at this on a microscopic level, meaning Canton PD and Massachusetts State Police, that they'd be willing to, I'd say, risk their entire business on the fact that they had to have knowledge that this or something like this would be coming out and they'd be getting called out on this shit. I mean, that's not to say, I mean, Cellebrite, like, I guess the question for me becomes is why? Why did they decide that they no longer needed to include reports on timestamps of that particular nature? Like in general, like, do they have an actual, like an actual explanation for that? Because otherwise it seems really fucking sus, right? It seems really fucking sus. I mean, to me, more data is always better than less data. So I don't know. I don't know. It's a bad look either way, no matter, unless there's a completely valid explanation for it, which I do not know. Sitting here, I have no clue. I do not know. But what I do know is it's a bad look. You've got the fact that they've removed it so that that particular artifact is no longer going to be shown in their reports. And then you couple it with Whiffen warning him that they were doing it ahead of time. It's a bad look. It's a really, really bad look. Okay, so Cellebrite released its physical analyzer standard, which also removed the 2:27 a.m. timestamp from its processing of the artifact. Notably, Cellebrite is a company that markets itself as providing digital intelligence solutions for law enforcement and is used by over. Oh, sorry, I already read that shit. Okay, so Axiom. Oh, that's right. I was talking about how much Axiom training he has. Axiom is an application product offered by Magnet Forensics, which is a competitor of Cellebrite. Best practices in digital forensics require forensic examiners to view data and artifacts with more than one tool. Therefore, I also processed the image of Jennifer McCabe's iPhone using Axiom version 6.11. Axiom version 6.11 reports the 2:27 a.m. search artifact for, quote, how long to die in gold, with a last viewed time of 2:27 a.m. in the Safari Suspended States tab section. Shortly thereafter, I contacted Magnet Forensics technical support to see if any additional information could be provided regarding this artifact. I was advised by the technical support that the 2:27:40 a.m. timestamp indicates that the search would have occurred sometimes at or before 2:27:40 a.m. time indicated. Let's go to see what the footnote says. Footnote 2, I would also note that Guarino's report labeled that specifically mentions that he also used the Axiom product to process a forensic image of Jennifer McCabe's phone. I personally tested the earlier version of Axiom, which would have been used in February of 2022, and determined that the 2:27:40 a.m. version of How Long to Die in the Cold search was reported by Axiom as having last been viewed at 2:27 a.m. That sounds like a big old fuck you moment right there. That that's bad. The question remains, kids, why was this information not brought up at the first trial? Why was it not brought to the attention of the jurors at the first trial? This was all information that was available at the first trial. Hmm. That's interesting. All right. So, moreover, Axiom's user manual describes this artifact as follows: quote, Safari suspended state tabs, last interaction, date time, UTC, end quote, as quote, the date and time of the current tab state when it was last interacted with on the local device. That is the definition that I have been looking for 2 years. Like, because that is the question. Like, the whole debate during the first trial was this folder that it was found in, and whether or not that thing was overwritten, and whether or not that was actually the search for the basketball team or whatever the hell she said she was searching around the same time. And like that particular sentence right there, the quote, the date and time of the current tab state was when it was last interacted with on the local device. This date and time will reflect when the user has last interacted with this tab in Safari, or if the tab auto refreshed on the local device only. End quote. In order to validate this timestamp, I looked at numerous examples of web sessions on Jennifer McCabe's device, including URLs containing Raining Men, Canton Ma, Hakama Sports, and EasternBank.com. In all of these instances, the browser state DB entry appears at the end of the session. This is consistent with how Magnet describes this artifact. So that's good work by Green. He goes back, says, "All right, so it's here on this one, but I'm going to go and I'm going to check other searches that she's done and go to other URLs and see if that artifact attaches the same way," which apparently it did. So, in order to confirm the accuracy of this search event as reported in Cellebrite Physical Analyzer and consistently throughout multiple versions of Axiom, I then independently performed a low-level analysis of the artifact, which was located in the browser state .db wall, write ahead file. I hope, for the love of God, he explains what the hell that is right here, right? I mean, that drove me nuts about that first trial. Because like I don't know shit about tech. Like you gotta tell me shit about tech like I'm a 5-year-old. And you need to assume as an attorney that you need to do that for the jury as well. You're making a massive mistake if you don't explain shit to a jury like they're 5 years old, because you need to break complicated shit down so that people can understand it. Uh Bev didn't allow what? You're saying she would not allow this in? Is that what you're saying, Radical? Yeah, DB, I watched it, dude. I don't think he did a good job explaining it. How about that? How about them apples, buddy? How about them apples? I watched every site. We streamed that trial, buddy. I don't think he did a great job. I walked away not having the answer from either side as to whether or not that goddamn thing was on that phone at 2:27 a.m. So in order to confirm the accuracy of this search event as reported in Cellebrite Physical Analyzer and consistently throughout multiple versions of Axiom, I then independently performed a low-level analysis of the artifact, which was located in the browser state.db wall, write ahead file. Write ahead files are temporary in nature and show the location where data is written before commitments to the main database are made. The particulars of this artifact are as follows: location, private. I don't know what VAR stands for. Variety, mobile, library, Safari, browser, state.db/wall, database record 4028, raw time data, long number, time converted to UTC, Saturday, January 29th, 2022, 7:27:40 a.m. Adjusted to local time, January 29, 2022, 2:27:40 a.m. I used 3 additional forensic tools to conduct a low-level analysis of the artifact in question, including Belkasoft X, Sanderson Forensic Browser, and ArtX, 2, a research-based program created by the Commonwealth's expert Ian Whiffen, which has only approximately 600 users worldwide. Little slap in the face there, Whiffen. Like, no one even uses your shit, buddy. Like that thing that you work so hard on to compete with the company that's employing you. No one even uses it, pal. So you guys, like, I'm trying to look at the chat a little bit, but I'm trying to read this thing. So I'm not going to see what Bob Guarino axiom was withheld from the defense. So that info wasn't available. See footnote 7. We'll get there. Okay, good. All right. So all 3 of these programs show data consistent with a search for House Long to Die in the Cold, with a last viewed time field of 2:27:40 a.m. being found on record 4028. All times listed have been converted to Canton, Massachusetts local time, unless otherwise noted. Thus, I was able to independently verify using additional forensic tools that the last time, date, and fact, the last viewed time, date, and fact of the search was accurate. It is my opinion, based on a reasonable degree of scientific certainty, that the user of Jen McCabe's cell phone searched House Long to Die in the Cold at or before 2:27:40 a.m. I have also consistently reported the existence of 2 additional search artifacts found on the forensic image of Jennifer McCabe's phone, which suggests that the user of Jen McCabe's phone made 2 additional similar searches later that morning on January 29th of 2022. 129-2022 at 6:23:51 a.m. How long to die and killed? And then 129-2022, How long to die in the cold? So, what is that? 30 seconds later? I mean, that concept that she was going in order to try to mimic the House Long to Die in the Cold that purportedly took place at 2:27, and she specifically made that error in order to mask the fact that she deleted it earlier, is an interesting concept. So opinion number 2, in my opinion, based on a reasonable degree of scientific certainty that the 2:27:40 a.m. search artifact for House Long to Die in the Cold was deleted by either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual. It is uncontested that the 2:27:40 a.m. search for artifact House Long to Die in the Cold found in record 4028 is in a, quote, deleted state, end quote. Databases contain tables with numerous fields, and in some cases, there is a programmed field entry to indicate whether a record is live or deleted. With regard to the browser state DB, which is the database at issue here, there is no such field to indicate whether a particular record is live or deleted. However, based on the characteristics of the data contained within the associated WAL file, the forensic tools indicate that the 2:27:40 a.m. House Long to Die in the Cold search found in record 4028 is in a deleted state. 18, there are several reasons why data may appear to be in a deleted state, which include a deliberate user interaction, an automated function of the operating system, a system application or operating system update, a malfunction of the operating system or hardware, or manual post-imaging manipulation of the data itself. I address each of these potential scenarios in turn. Now he's getting to it. This is the shit. They may not have had an axiom, but he should have broke this shit down like this at trial. I don't know. Manual post-imaging manipulation of the data. So he's starting from the back and working his way to the front. So typically, data collections have an associated hash value, which is unique to that set of data. The hash value is created using an algorithm and is a well known mechanism used to validate the data and ensure that it has not changed or otherwise been manipulated. In this case, USF was originally supplied with a forensic image of Jennifer McCabe's cell phone, which was created with a tool known as Gray Key from Assistant DA Lally by way of Guarino with the Stades. However, and remarkably, the associated documentation containing the hash value needed to validate the image was not provided with the initial USB drive containing the forensic image of Jennifer McCabe's cell phone. This was incredibly unusual. In all my years of working as a forensic examiner, this is the first time I have ever received a forensic image of a phone without the corresponding hash value. What I'd like to see is I would like to see discovery that they have sent, in particular Guarino, has sent to other experts in other cases to see if they've ever done that before. Because if this is a one-time deal, it's a bad look, man. It's a really, really bad look. I mean, that's like classic hide the ball shit there. So after personally insisting that the Stades provide the hash value associated with this data, USF was eventually provided with a PDF containing the purported hash value, and the value listed within that PDF matched the gray key image file of the cell phone in question. However, as Mr. Whiffen acknowledges in his report, the Celebrate program cannot validate the data because the value is unsigned. In other words, the gray key image of Jennifer McCabe's cell phone could have been manipulated, then rehashed after the manipulation, and still show the same resulting hash value included in the PDF file. Man. Typically, forensic examiners are provided with the raw image file and the associated hash value documentation together. After validating the hash value, I would then accept that the data has not been manipulated. Here, however, the hash documentation was not provided with the raw image of the cell phone. Instead, it was withheld from the defense. As a forensic examiner, having received hundreds of imaged phones over the course of my decades long career, this was unprecedented. In addition to law enforcement's failure to initially provide the hash documentation associated with the raw image of Jennifer McCabe's cell phone, there were additional anomalies within the process data that are suggestive of manipulation, as reported by tools such as Celebrate and Axiom. Wow. Boy, oh boy. These anomalies discussed in further detail below, along with other anomalies in this case, including law enforcement's failure to properly document the chain of custody. Ooh, ooh, I'm big. I'm big on the chain of custody. Start fucking with that, your evidence is shit. That's how it goes in my world. You don't have a proper chain of custody, you got nothing. Because I hate to say it, but I'm a little bit suspicious of police. Go figure. So, along with the other anomalies in this case, including law enforcement's failure to properly document the chain of custody of items of evidence, inconsistencies in official reports and testimony regarding the collection of evidence, law enforcement's failure to properly photograph and document the evidence, and the destruction of other crucial electronic data are all suggestive of post-imaging manipulation. Wow. So B, this is another way it can happen. Now I know why he started with manual post-imaging and manipulation of the data. Now we know. Now we know why he worked his way back backwards, forwards, right? That's pretty damning shit. B, the malfunction of the operating system or hardware. This is a shorty. In my experience, iPhone hardware and the ISO operating system are very reliable. In this case, there is no data or evidence to suggest that a malfunction of the operating system or hardware caused the deleted record. System application or operating system update. The structure of databases can change from version to version of the iOS system or associated applications. Upon analyzing Jennifer McCabe's cell phone, I was able to determine that the iOS on this device was updated to version 15.2.1 on January 24th of 2022. This update occurred before the record in question was generated on January 29th, 2022, and would not have been the cause of the deletion. Wow. All right. I mean, D, automated function of the operating system. The artifact in question is found in a wall write ahead log. The data is written to a temporary wall file in order to aid in speed and ensure data integrity. You can think of this as a database being in a series of Excel spreadsheets where the data is structured into fields, rows, and columns, and the wall file is a notepad text document where you're quickly adding data that you intend to eventually write into the Excel spreadsheets. Thank you. Thank you, Richard Green. See, that's the way I need it broke down. Like, I don't pretend to be an expert on everything. And like, this is technical shit. So that's the kind of breakdown, like, so that I can visualize. I obviously know what an Excel spreadsheet is. I obviously know what the notepad text document is, which is like you could just stick shit over there real quick. And it's kind of like you're holding it there. It's like a holding spot until the wall file's ready for it. So the WAV file as the notepad document where you're quickly adding data that you intend to eventually write into the Excel spreadsheets. The mechanism for writing the data from a temporary WAV file to the associated database is called a checkpoint. Here, with regard to the 227 40 a.m. House Long to Die in the Cold WAV file at issue, the data establishes that the last checkpoint occurred on 128 of 2022. It's 7:39:03 a.m. Therefore, the deleted state of the 4028 record is not a function of the wall file being written to the database because the last checkpoint occurred the day before on January 28th of 2022. I am aware of no internal mechanism for spontaneous record deletion. Mr. Whiffen simply concedes in his report that he is unaware of any, or similarly concedes in his report that he is unaware of any internal mechanism for record deletion. And yeah, you weren't lying. Like, Green's lighting it up. He's lighting it up. Again, I'm going to say it again. Like, I wish that he could have gotten to this kind of detail with maybe some demonstrative evidence for the jury to look at. You know, I mean, like, this is the kind of explanation so that the jurors can understand what the hell you're talking about at trial. You can't assume that the jurors are going to understand this shit. Deliberate user interaction. As stated above, there is no internal field with the browser state DB database to indicate whether the artifact in question was user deleted, i.e., a column labeled deleted with a corresponding entry of yes or no. No such field exists in the browser state DB database. However, as explained in further detail below, additional anomalies found on the phone strongly suggest that this data was either the result of deliberate user interaction or post imaging manipulation. That's nefarious. I mean, you guys get what the layman, like, just the everyday, like, post-imaging manipulation is the cops fucked with it. They fuck with the evidence. Post-imaging manipulation is just a fancy word. That's all just words. That means the cops fucked with it, or she deleted it. So deliberate user interaction is McCabe deleted it, or they changed the shit up at the cop shop. Oof. Oof. All right. 19. My forensic analysis of the image of Jennifer McCabe's cell phone uncovered numerous anomalies or unusual deviations from what is standard, normal, or expected in a typical case. The following anomalies further support that the artifact in question was deleted either through user interaction or through post imaging manipulation. Anomaly 1. The most up to date version of Cellubrite Physical Analyzer reports 4,560 searches with only one search being marked as deleted. Oof. The only search marked as deleted in the most up-to-date version of Cellubrite Physical Analyzer is the "How long to die in the cold?" Boop. In the most search found in the browser state DB record 4028. This strongly suggests that this search was targeted for deletion. Anomaly 2, the tab ID for record 4028. That thing there, that long series of numbers and letters. This number is unique to the tab in question and would have been used for all URL history in that specific tab within this particular database. The Commonwealth has claimed that the actual website being visited during, oh man, he's bringing it all. He's bringing all the shit. This, the Commonwealth has claimed that the actual website being visited during this period was hockamocksports.com. However, the tab ID recorded at 2:27:36 a.m. associated with the hockamocksports.com website or web activity has a different tab ID number, specifically different numbers and letters than the ones up above. Ooh. Ooh. So, thus, the records in question clearly established that the hockamocksports.com activity was conducted in a completely different tab than the search for Haas long to die in cold, which also showed activity at 2:27 a.m. just seconds later. Mm-hmm. Anomaly 3. The Commonwealth's experts, Ms. Hyde and Mr. Whiffen, opine that the 4028 record with the 2:27:40 a.m. timestamp initially would not have been associated with the Haas long to die in the cold search. I have examined the multiple write-offs, the rights of the 4028 record contained within the browser state DB wall file, and in all instances, the URL containing "How long to die in the cold" was present. I see no evidence of the 4028 record containing a different or blank for that field. Oof. The search artifacts associated with "How long to die in the cold," "How long to die in the cold," and "How long to die in the cold" at 6:24:18 a.m. are all missing information that would be expected in the history.db file. Mr. Whiffen opines that the load was likely never successful. It was never populated in the history.db database. End quote. However, the Google suggestion artifact for "How long to digest food" appears at 6:23:49 a.m. along with a picture. This indicates that the cell phone in question had internet connectivity at the time of 6:24 a.m., at the time of the 6:24 a.m. search, and contradicts Mr. Whiffen's speculative suggestion that the load did not complete. Anomaly 6. Oh, little backslap there for the old Whiff nerd, huh? Anomaly 6. The knowledge C information for the "How long to die in cold" search appears to be out of order. Knowledge C artifacts typically run a few seconds after the event in question. For example, the P list time for "How long to die in recorded at 6:23:51 a.m. and has a corresponding knowledge C time entry of 6:23:57 a.m. 6 seconds later. Typically, the knowledge C artifact appears second after the P list entry. So typically the knowledge C artifact appears second after the P list entry. However, the 6:24:18 a.m. P list entry for House Long to Die in the Cold is followed by a knowledge C time of 6:24:24 a.m. 6 seconds later. For House or How Long to Indict, the corresponding knowledge C entry for House Long to Die in Cold does not show up until hours later at 10:35 a.m. This is unusual and deviates from what is usually observed. Typically observed. My fault. Shoo! This is a lot, y'all. This is a lot. And I'm here for it. Anomaly 7. Guarino's April 24th, 2023 report shows that he took custody of the phone on 2/2 of 2022 at 12:08 p.m. However, the gray key log indicates that the device was not accessed for imaging until 2 hours later at 2/2 of 2022, 19:25:40 UTC, or converted locally as February 2nd, 2022 at 2:25 p.m. The report also indicates that he was given the password to the phone. Nowhere within the report does it explain the time delay between receiving the device and imaging the device. Where's Allie? I need my sound effect. Dun, 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 dun. Hold on. I'm going to find it.
Only guilty man in Shawshank.
So that wasn't it. Just kidding. Love that soundbite. I don't know where it is. I'm going to keep reading. All right. It is my opinion, based on a reasonable degree of scientific certainty, that the 2:27:40 a.m. search artifact for House Long to Die in the Cold was deleted either by deliberate user interaction or manual post-imaging manipulation of the data by some, quote, unknown individual. See, he's stopping short of firing on the cops. You don't need to be a rocket scientist. I mean, it's either McCabe or the cops. Can only be. Who else had the phone? Can only be one of those two, cops or McCabe. All right. Okay. The methodology I used to evaluate the 2:27:40 a.m. search artifact for House Long to Die in the Cold, as described in this affidavit, is generally accepted in the digital forensic scientific community and is consistent with applicable NIST, National Institute of Standards and Technology guidelines, as shown in Digital Investigation Techniques, a NIST Scientific Foundation review, and is attached as Exhibit B. What? All right. Green coming with the heat. That was a good read on a Wednesday afternoon. Oh boy, oh boy, oh boy. Well, I'm gonna have to go through and read all your comments. This is yeah. Green came with the heat. Like, where was this guy on the stand, though? It's one thing to write a report. You got to be able to sit on that stand and articulate it to the jury. They're going to have to prep him better. They're going to have to prep him better for the next trial. He's got to be ready to sit on the stand and explain that shit. Maybe Bev will let him read straight from his report, but I doubt it. But the easiest way to do this for the team over there is just create demonstrative evidence, throw it up on the big screen, and then he'll go through it point by point. This has to be explained in this way in order to really get the jury to kind of wrap their minds around it. Because what happened at the last trial just was not sufficient. Just wasn't. Like, the only thing I wanted to know during that entire goddamn trial was whether or not that search actually took place. And I walked away wanting. I was wanting. So, I mean, that's some good work by Green. Does anybody think that maybe Elise actually wrote that? I don't know. Elise's really smart. I don't know. I wouldn't put it past him. Wait, is there a footnote I missed? Where? I don't think so. I'm going through again. I read 2 for sure. Maybe I missed 1. It's possible. Oh no, that 1 is just the what do you guys? What's the other footnote? Where's footnote 7? There's only 2 footnotes in this particular document, y'all. Like, you're looking at the document. I'm scrolled right through it. Here, I'm going to pull it up. Are you guys talking about the right document? Or are you talking about a different document? Let's pull it up. I want to bring receipts. Or maybe I'm just completely missing it, which is possible. But I don't think so. I've read a legal document or 2 in my time. All right, so let's see. There we've got, as you can see, footnote 2. Okay. That's page 7 of 13. Okay, now we're at the bottom of 8, nothing. Bottom of 9, nothing. Bottom of 10, nothing. 11, nothing. 12, nothing. 13, nothing. Where are these footnotes, y'all? No, I read all of number 2, Tiff. Read all of it. My mind was blown by 2. I read all of it. All of it was read. I didn't skip one word of this entire document. And this was a wordy document. Very wordy document. Now, I read every single word of it. I'll read it again because I liked it so much. Wait, defense, you didn't read the whole footnote to US. Please tell me what US means. I don't know what that means in terms of. So footnote 2, not the footnote. Well, what are you yelling at me for? They said the footnote, Mandy. All right, I'm going to read footnote 2 and then y'all get your shit clear and tell me what you want me to read again. Because if there's something of interest, I definitely want to read it. I definitely read the last sentence. I'll go back because the cool thing about this particular StreamYard program that I use is it records all my shit so I can go back and watch it. But I'll read it again. I would note that Guarino labeled his report labeled all those letters. Specifically mentions that he also used the Axiom product to process the forensic image of Jennifer McCabe's phone. I personally tested the earlier version of Axiom, which would have been used in February of 2022, and determined that the 2:27:40 a.m. version of the House Long to Die in Cold Search was reported by Axiom as having a last viewed time of 2:27 a.m. Axiom has a similar feature to Celebrate with their creation of a portable case. Maybe I didn't read this. That does not ring a bell. This exculpatory information was never turned over to the defense, but I remember that. I think I remember that. No, Doug, that's Osbrook's nickname is. He's footnote Charlie. All right. So is there anything else I missed? Yeah. I mean, look, y'all, this is pretty damning. It's pretty damning. Pretty damning stuff. Thank you, Mandela. She did it. Wow. So look, I think that you're welcome, Pokey. I think that Elise is absolutely correct that this is not, it's the same thing that happened with Russell Like, I almost kind of want to see Brennan go in there and make a total douchebag out of himself, though. But as they aptly note in their motion, hearings like this eat up a massive amount of preparation time for trial, because the only thing that really matters at this point is trial. And we're talking an April trial. And you guys have heard me say it before. Time does not move in a normal fashion if you're an attorney preparing for trial. It flies. There's not enough hours in the day. There's not enough people working for you. There's not enough time to accomplish everything that you're trying to accomplish. And panic sets in. So, having to go travel back to Canton to go into this thing. I was actually thinking about that, DB. I was when I heard about this coming down the pike, I was thinking about Stacy to see I could reach out to her. I'm sure her number's in the phone book. And she might come on. I don't see why she wouldn't. She and I thought she was good. I thought she teaches the feds. As much as McClellan tried to shit on her, I found her to be very reputable and knowledgeable. And found shit. Like we have finding things and understanding things that the cops didn't understand is always good. It's always good. So yeah, I will check in on that, because I'd love to even be able to pick somebody's brain, because this stuff is super foreign to me. Like I am not a coder. Like I'm obviously not a boomer, but I'm super Gen Xy. And this wasn't in our wheelhouse in grade school, in high school. Like that, this wasn't shit that we were being taught. So coding is exceptionally foreign to me. And all of this seems like coding to me, or some version of coding.
Are you sure?
Yes, Mandy. Good job on learning that those are all on a loop and will go on for
Bukkake.
So big day for the defense, I would say. But to kind of wrap it up here, I think that Alisi is absolutely correct. This is not a Daubert issue. This is an issue for the jury to decide which side they believe, period. That is an issue of fact. That is not an issue of methodology and or whether or not this methodology is viable and helpful to the jury, because it clearly is. You have a disagreement between experts as to what's taking place. That's exactly what you leave to a jury. I mean, if by that logic, there would be no fucking trial, because everything that happened in this case is being disagreed about. Like no one is agreeing to anything. Yeah, he was hit. No, he wasn't hit. No, he was hit, not hit. I mean, it's if you follow this logic, the state can't put anything on. Like what? Because they're the state, they're right? Get the fuck out of here. I reject that. Obviously. It's a theory. It's all it is. I've said it a million times, and I'll say it a million more. It is a theory and nothing more. And so you have to have a jury sit there and listen to both sides, and they determine, them and only them, determine which fact they choose to believe is true. That's it. That's why juries exist. And you hope that they're good jurors. Which is always scary. All right. So you guys are amazing. I love you. We had a nice crowd in here. Sorry it was a little disjointed. I had a bunch of shit going on. I had an interview with somebody we were very excited to interview on for the Songbird Road podcast that I'm doing with Lauren. It ran longer, but I expected it was going to run long. And then I recorded a Garcia. So I was late to the party. I'm sure Allison was fabulous. She always is. You guys are fabulous. I love all of you. Let me give some thank yous out here and read real quick. My girl, Sleuthy Goosey, what do you think about Ian Whiffen reaching out to Green during trial? I think it's fucked. I think it's absolutely fucked. Now, the question becomes, is there impropriety to that, in that it can be brought up at trial and some kind of punitive remedy is enacted by Judge Bev, meaning I'm seeking to get that fuckhead barred from testifying because he's trying to harass my witnesses and he's threatening to delete things and did in fact delete things. It's the way it seems. I mean, that's the way this reads, right? It's the way it reads. Can't read it any other way. So, Lisa Shelton, what have we learned from John's phone? My health app shows when I fall. Yeah, I mean, you probably, what do you have, Lisa? 15, 16? I just realized that I was going to test myself for apnea with my Apple Watch. And I've got a version 6. They make those things which doesn't have the sleep apnea thing. So I think it depends on, I don't know if his Apple Health data back then had that as a feature on whatever phone he had. I don't know. But thank you for your support. Lisa, I think that it makes sense that Celebrate updated to remove the wall timestamp if they can't prove as a solid fact that it's a reliable timestamp on its own without analyzing other data to avoid confusion. Now that makes sense. That's a reasonable counter argument. Because I mean, the one thing that about these companies that exist, and I talked about it ad nauseum in the Richard Allen case, is these companies literally exist in order to try to figure out the secret sauce of Apple. Like entire industries exist trying to figure out that alien technology that's taking place in the Apple building with all the little aliens walking around using their alien technology. Like that's literally what these companies exist for, to try to figure out how to get to and crack so that they can look at the under the hood shit, as Stacey Eldridge called it, and to see what's going on with Apple. But is just getting rid of it and pushing it to the side and pretending like it doesn't exist, is that the right move? I don't think so. I think that maybe you can put an asterisk by it and say, hey, we haven't really figured out what this is yet, but we're going to keep it in here because it was on the phone. You can't let law enforcement start deleting things, or companies that provide their software exclusively to law enforcement to start deleting things that law enforcement doesn't find helpful. We want all the data. That would be my counter. But thank you for your generosity, Lisa. I always appreciate it. Veta, I think I read this one during it. I'm usually a rewatcher, but I wanted to read it because they caught alive. You finally caught alive. My husband is incarcerated. I'm sorry about that. Unless he, of course, deserves it. Maybe he doesn't. And I usually can't watch true crime. The humanity you show for convicts and tasteful coverage gives me hope. Keep fighting the good fight. Always. Always. I mean, people incarcerated are human beings, and I don't know any of their backstories, and they're serving the time that they were sentenced to. So, I mean, they deserve to be treated exactly as everybody else does. I mean, they're already held in a cage, which is pretty awful. So, Marissa, $2 holla. Bev is doing a bench trial now. You should check it out. I saw that. It was for the wealthy woman who is alleged to have killed her husband, like run him over or something like that. I saw it. It's on Law and Crime, right? They're streaming it. I'll peep it. Thanks, Marissa. DSN, $10 holla. Appreciate you always, DSN. Jennifer Crumbly hearing on Friday, y'all. Big one. Couple big ones on Friday. Couple big ones. Reads Up and Crumbly. We're gonna have to. I want to cover both. You guys know that I very much want to cover Crumbly as well. It's one of the ones in my wheelhouse. So Afton, appreciate you always for gifting that one DD. You guys, quite simply put, are the best in the business. We love you. We love you. We love you. Oh, free. Good. Yeah, that thing, Darren's got it in his hands. 64 should be out. Yeah, man. Well, we're about to get into the shit. Like anybody who thinks that we're not going to talk about what happened out there, like people like to, when they try to discredit Allie and I, they're like, Allison got kicked off that case. You're goddamn right she did. Fighting like a mofo for a client. And she doesn't shy away from any of that stuff ever. Like, people just don't know us. They got the wrong ones when they think they would mess with us. So, all right, you guys are the best. I love you. I will see you tomorrow. We're going to do something fun, something interesting. We'll figure it out. But make sure you check it out. Make sure you like, share, subscribe on the way out. It really means a lot to the channel. We really, really appreciate it. Make sure you're listening to the Defense Diaries podcast. It's a great one. Really proud of it. It's great. The docket's one thing. Like the docket, most of that you hear here. But Gacy and Garcia, they're worth your time. If you're bored, give it a listen. I think you'll like it. I think you will.
Thank you very
And
much. Thank you very much. Thank you.
Thank you very much. It's Latka. Oh, thank you very much.
and last but not least, make sure you're listening to Murder on Songbird Road. New episode drops tomorrow, episode 5. And it's a gut wrencher in terms of how they treated this woman. Once again, another pretrial detainee being treated like an animal, a savage. So check that out. Make sure you check that out. And you guys, I want you to take care of yourselves tonight. Treat yourselves like the kings and queens that you are. And I will see you all tomorrow, because if you're not here, I'm just an old man talking about all kinds of cases. See ya.